good morning to everyone who's joined us. You have found us at the Miller-Johnson 8 a.m. COVID seminar, and today we are talking about multi-state compliance, employment compliance across state lines. And I am joined here by my colleague, Matt O'Rourke. My name is Sarah Willey, and thank you for joining us. Matt and I decided to put together this seminar as we found that we had an increasing number of businesses and clients calling us with compliance questions outside the state of Michigan. And what many of them told us was that they had people working outside the state of Michigan, even though maybe they were headquartered here before COVID. But in the last year or so, since COVID has hit, they have found themselves with employees that they've either knowingly hired out of state or employees who have been working remotely and have chosen to do so out of state in a state other than Michigan, and that has potentially become a long-term arrangement. So that has left us with an interesting new conundrum as employers, and that is, when do I have to comply with the laws of other states, and how do I do that? And so we've put together here at Miller-Johnson an entire task force for that, to answer those questions. And first in line on that task force is my colleague here, Matt. He's going to do the bulk of the presenting today, and you'll quickly discover why Matt is head of that task force, and that's because he is smarter than I am and understands the ins and outs of the laws of really all 50 states. So we're going to dive in a minute. I'm going to talk to you a minute just about what we're going to cover. We obviously cannot cover the details of the laws of all 50 states, and that's good news for all of you. We are going to be done here in 45 minutes or so, or perhaps an hour with questions. But what we want to talk to you about are sort of the highlights, the main areas in which you all need to be thinking when you have employees who work in other states. And we are also going to be talking to you about when you have to worry about that. In other words, do you have to be thinking about somebody working in another state just because they rented an Airbnb for a month? Do you have to think about that when you only have one salesperson who's working out of his or her home, et cetera? So Matt's going to cover all of that, and then I am going to help with questions as we go and wrap it up at the end. So Matt, go ahead and take it away.
All right. Thanks, Sarah, and good morning, everybody. Happy Friday. We made it to another one, and thank you for joining us this morning. Where I am going to start today is exactly where Sarah left off. A question that we get a lot is, when do these laws kick in? When do we need to be worried about the laws of another state? Like Sarah said, we get questions like, we're a Michigan-based company and we have an employee working in California. How long does the employee have to be working in California before we need to start worrying about California laws? So let me start with the bad news. Unfortunately, there's no bright line rule. We can't say that after X amount of days or weeks, all of a sudden you need to start worrying about the laws of the other state. But what we recommend is focusing on the nature of the employee's presence in the state, not the time. So let's consider that California employee. If the employee moved to California and now lives there full time, then California laws are almost definitely going to apply to that employee and his or her employment. Excuse me. If, on the other hand, though, we're in COVID, people are working remotely, it's cold in Michigan, and the employee decided that he or she was going to rent a cottage on the beach and stay there for the 4 months of the winter, and then come back to Michigan, well, then we probably have a different situation. That seems more like a temporary arrangement, and there's a good argument under those circumstances that California laws would not apply to the employee. So as we go through all this and as we go down our list of the subjects that we really need to be aware of as employees start to branch out across the country, I'm going to keep two things in mind. First, this is a new phenomenon. Laws weren't passed with the thinking that employees would be working in one state but reporting to an employer across the country in another state. And if you ever talk to me, one of my favorite things to tell you is the law moves slowly. We're dealing with laws that were passed decades ago, and they never even contemplated this situation. And so while we expect states will try to adapt and adopt new laws to these changing times, right now we're stuck trying to fit a square peg into a round hole. And sometimes that means that even though it really seems like a law wasn't meant to apply to some of our employees, it might, just because of the way that it's written. Second, if you have employees working in other states, but you consider that arrangement to be temporary. So it's that lucky employee who rented a cottage on the beach in California for 4 months, but everybody expects that he or she's going to come back to the office when COVID is done, if it ever is done. We recommend that you note the temporary nature of that assignment in your remote working agreement. We can't necessarily control by agreement which laws do or don't apply to our employees, but at the end of the day, again, because this is a fluid and constantly changing situation, if we have documentation showing that we all agree that this is a temporary arrangement, that's only going to help us if issues about which law applies come up and arise. So, like Sarah said, today's webinar is going to focus on 10 or so employment-related issues, but really dealing with these issues require a comprehensive approach. Having employees work in other states, whether it's permanent or temporary, could mean that your company needs to register in that state and withhold income tax. It might require changes in the way you process payroll, in terms of how frequently you pay employees, what information is included on their pay stub, when their final wages are due at the end of employment. So in addition to what we talk about today, today's really designed to be a primer to make sure that you're thinking about some of these issues as your employees spread out across the country. But tackling these issues really takes a team. So we recommend working with your accountants, your payroll services, and any other entities that you're working with to make sure that you stay on top of these issues. So with that, let's get started to topic number 1. Minimum wage and hours worked. This should be pretty simple, right? Well, based on the last couple minutes of me talking, I'm guessing that you know the answer is, well, no, not necessarily. First, let's tackle minimum wage. This map is from the U.S. Department of Labor. It doesn't show you what the minimum wages are in each state, but it gives you an idea of how minimum wage can be different across the country. Most states have some sort of minimum wage which is different than the federal minimum wage, which means that state's minimum wage applies. And depending on the way that the state's law is written, it could mean that that minimum wage applies to employees who are working in that state. Other states don't have any minimum wage at all, or they apply the federal minimum wage. The purpose of this is just to illustrate the point that what works for our employees in Michigan or what works for our employees in the state where you're based might not necessarily work for our employees who are working remotely. That also goes for hours worked. Different states define hours worked differently. And so issues like on-call pay, reporting to work pay, preliminary and post-preliminary activities. You know, the FLSA, which most of us are governed by and which applies in most situations, says that for a lot of preliminary and post-preliminary activities that are not part of an employee's principal activities, that they don't have to be paid. But other states might have different requirements and might say that they do need to be paid. So it's important to stay on top of these issues, to check your timekeeping and rounding practices, and just to make sure that employees are getting paid what the law requires them to be paid, because wage and hour issues can get messy and they can get expensive. So getting it right the first time around is an important goal. Topic 2. You mean to tell me that overtime is more than just working over 40 hours in a week? Well, yes. Some states, and those listed there, Alaska, California, Colorado, Nevada, Puerto Rico, not a state, but a U.S. territory, and the Virgin Islands, again, not a state, but a place I'd like to be right now, all have different overtime laws when employees work more than a specific number of hours in a day. Typically, these laws kick in when employees work more than 8 hours in a day, but some states have laws that say employees get paid time and a half when they work more than 8 but less than 12 hours in a day, and they get paid double time for any time that they work over 12 hours in a day. So again, we need to stay on top of this and the individual state's requirements. When we talk about exempt employees, employees who are exempt from the minimum wage and overtime requirements, different states sometimes require a different salary than what the FLSA requires nationally. So as I'm sure you're familiar with, the FLSA tells us that salary exempt employees need to be paid at least a salary of $684 a week or $35,568 a year. But Alaska, California, Colorado, Maine, New York, Pennsylvania, and Washington all have a higher salary basis. Way back when, if you can remember our pre-COVID times, Governor Whitmer here in Michigan actually tasked the Wage and Hour Division with looking into increasing Michigan's salary basis to a number that was higher than the federal number. COVID has put that on the back burner or completely taken it out of the kitchen for the time being, but it's out there. And if and when things return to normalcy, we might see Michigan be one of the states on the list here where the salary basis is higher than the federal standard. And in some cases, the state standard is considerably higher. California's, for some employers, is almost $20,000 higher than what federal law requires. So again, these could be some significant changes, but things that we don't necessarily think about when employees go and work in a different state. And finally, the duties test. This goes along with everything else when we're talking about exempt employees. They have to meet the salary basis. They also have to make sure that their duties meet the requirements in the law. And different states have different duties tests for what is required to meet a certain exemption. Topic 3, rest periods, meal breaks, days of rest. Are you actually ever going to work? So part of the reason that this is important, at least for our Michigan-based clients, is because Michigan, in terms of what it requires of our employers, is really pretty generous. It doesn't have a ton of specific requirements in terms of rest breaks, when rests have to be taken, how long the rest break has to be, meal breaks, how often and how many meal breaks employees get over the course of a shift. And so other states are not as generous, and they do have specific requirements. Oftentimes, down to the point of if employees work 4 hours, they're entitled to one rest period scheduled no later than 2.5 hours into the shift. And if they work 3 8-hour shifts over a certain week, they're entitled to this many rest periods or that many meal periods. And so the requirements do vary by state. And it's important not only for employee morale purposes that employees get their breaks, but also typically there are fines and penalties associated with not giving employees their breaks. In some states, this is not as common as it used to be, but some states require employees to have a day off, 1 day of rest, typically 24 consecutive hours of not being scheduled to work within a 7-day week. This, back in the day, used to be a Sunday law. Employees couldn't work on Sundays, and now it's more general, where usually it's just any day during a 7-day period. Employees must have at least 1 full day off. Again, not as common anymore, but there are a few states out there that do require 1 day of rest in 7. So, Sarah, before I move on to the next topic here, that covers some of our general wage and hour issues. Are there any questions out there that we can answer, or anybody who's listening and following along, if you have any questions, please go ahead and submit them, and this would be a good opportunity to answer anything about what we've covered so far.
Sure, and thanks, Matt. We've got a couple of questions that are more broader based, and I know we're going to be talking about them at the end too, but I think it makes sense to sort of start to begin this conversation as well. And the questions are along this line. So if I have people working in several states, let's say like 17 or 37 states. And there's different pay rates and rest breaks and meal breaks, and there's different rules about when they have to be paid. Do I have to follow the most strict rules for all of my employees, Matt? How does that work?
Well, that's a good question. And I know in a lot of situations, we've worked with clients who have folks spread across the country, but oftentimes we don't have a lot of employees working in individual states. It might be 3 employees here, 4 employees there. And so I understand the administrative costs of just trying to figure out what's required and then apply all these laws can be significantly higher than what it feels like it is worth it, even though we absolutely need to require or to comply with the laws. And so there's a couple ways to go about it. One would be to look at each individual state and apply the laws of that state just to the employees in that state. And that's where the administrative burden can really come in, because then we're balancing the laws of many states. Another option would be to take the state that gives the most generous or most employee-friendly benefits and apply that universly. Typically that would work, and that makes it easiest, I think, in terms of administering all this. Where we need to be careful, though, is let's take rest and meal breaks, for example. Some states require that those breaks occur at certain points in the day. So again, if an employee is working a 6-hour shift, they might require that the meal period occur no later than halfway through that shift. So to the extent that we can generalize this, I think that's a much easier way for us to do it, and something that would work. The law is never going to penalize us for being more generous than what's required. But at the same time, I don't want to say just run off, find the most generous state and apply that to everybody, because some states do have specific requirements that we have to comply with.
Right. Yeah, and to be clear, it's okay to have different pay and breaks and other benefits for employees that are dictated by state requirements, right? So generally in the HR world, we apply something called consistency, right? That's how we think as a general rule. And what you all are going to find if you have people working in different states is that to some degree, we might have to let go of the idea of perfect consistency in order to comply with the laws of different states. And as you'll hear in a little bit, that's going to be particularly true if you happen to have hired somebody or employing somebody who works in a state like California, right? It's not going to be an option likely for you to afford California legal protections to your entire workforce. Okay, so with that, hold on, let me see. One more question came up. This question is, are there certain cities we need to watch for employment law as well, Matt? In other words, this presentation is focused on states. Is it the case that cities can also have their own rules?
Unfortunately, and I say that only because it makes it harder to administer, but unfortunately, yes. So we don't see this in a lot of states, and I'm guessing we can all list the states where this is the biggest issue. But states like California, New York, Massachusetts, Illinois, a lot of those states, in addition to having specific requirements which might be different from what we're used to dealing with for our Michigan-based employers, also some of the cities in those states have their own individual requirements. And I'm guessing we could probably list those cities too. So places like San Francisco, Berkeley, Chicago, New York City, Boston, those are places that frequently have their own requirements. And so to the extent that you have employees working in different states and in some of these cities, that's not covered in today's presentation because we didn't want to keep you here all day, but also something that we need to be aware of. The way states differ is typically something like a minimum wage or salary, not even salary exempt status, but a lot of times minimum wage. There's some drug testing requirements out there, and we'll talk about drug testing a little bit later, but some cities have specific requirements for drug testing applicants or employees. So there are some differences out there based on city.
Sure. And that's also, not to be really depressing, but that can also be by county as well, right? So you can have layers. Now, again, that's not common in all states to have layers of different rules by city and then county and then state. And we know where those are. But one example is here in Kalamazoo. Kalamazoo County had passed an ordinance protecting or providing discrimination rights to the LGBTQ community long before that was folded into Title VII by the Supreme Court this summer. So that's just one example of things that we're thinking about complying with. I'm just going to ask one more question before we move on, because again, it's more of a general question, but I think it's important to have a good framework as we're going through these specific topics. And that's, we're finding that some employees have already moved and these requests were approved by their leader with no HR involvement. Boy, isn't that a familiar story, Matt? We've had so many clients call with that, right?
Yep.
My employees were working remote during COVID, and they were smarter than we were and realized that they could do that from fill in the blank, Hawaii, where take care of their parents in South Dakota, whatever it is, right? They up and left, and now they are working from another state, and they didn't necessarily tell us. How do we handle these in terms of thinking about which states we might allow employees to live in as we develop our guidelines? Should we be thinking about that as a framework? And I know what your answer is, and I know you're going to have more information about it later, but can you just give us a teaser on that?
Sure. So yes, that's something we should be thinking about, and that's first things first. We probably need to have a conversation with that supervisor or that leader to make sure that we're all on the same page there, and then curse him or her behind their back. But there's a couple things we can do there. So Sarah, like you said, you're beating me to the punch a little bit. We're going to talk about some states that I believe are more difficult to deal with than others, and states that we would recommend that if you're concerned about complying with the laws, that maybe you prohibit employees from working in that state. And we need to be careful with how we do this. It shouldn't be in response to an employee's claim for additional benefits or anything that could look like retaliation. But again, this is a changing area of the law because this is also new. But as of right now, the location where an employee works or the state in which an employee works is not a protected characteristic. So we have every right to tell an employee that they have to work in a certain state, or that they can no longer work remotely in certain states, or whatever it might be. Now, that's the legal answer. From the employee relations perspective, we also need to make sure that we handle it so that we don't push away our good employees who might have been ahead of the game and might have rented that cottage out on the coast in California before we knew what was going on. And that's a more kind of nuanced conversation that we need to have with the supervisors and employees about how we do this. But in terms of regulating where employees are working, we have every right to, as of right now, say you need to work in Michigan, or you can only work in these states, or whatever it might be, to keep control over it. And I think the initial thing we need to do is, first and foremost, then figure out where our employees are, so that we can stay on top of it and then address whether or not we're going to allow them to continue to work from there.
Great. And lastly, there's just I'm getting a couple questions about how are there resources to comply, et cetera. And again, I'll just give you a teaser and tell you we're going to be talking more about resources that we've developed to help businesses both understand what the current requirements are and put together policy addendums, and also, and perhaps most importantly, to keep in compliance. In other words, figuring out what we need to do now is a huge project, but that might even be the easy part. The harder part is knowing then when there's a significant legal change in one of these states, so that we don't drop the ball on that. And so we are going to be talking, hang on, we're going to be talking more about that at the end. All right.
We promise it's not all doom and gloom.
Exactly right.
Okay, let's move on to topic 4 then. The next few topics, we're going to talk about different types of leave that are required by different states. And so, again, we're based here in Michigan, and most of our attendees are from Michigan. You're all familiar with paid sick leave or paid medical leave, which came through Michigan a couple years ago. This map shows you the different status or areas, states in the country that have some sort of required paid sick time. The red states like Michigan are where the requirements are at the state level and only the state level. It makes it a little easier to comply with because then we only have the one law to deal with. The purple states are those where there are both state and local requirements. And then the blue states are where there are only local requirements. And so, Sarah, this is a nice connection to what you just said. This seems daunting and frightening. I fully understand it and get it. We're on top of this, though, and we'll talk in a little bit about how we can help you through it. But just because states or localities have the paid sick time requirements doesn't mean we just need to be aware of it, but we need to be aware of how those requirements differ by each state. And in some things or some ways they might be different is which employees are covered, which employers are covered, how does paid sick time accrue, how can it be carried over or can it be carried over from one year to the next? And you can see the list here. I don't need to read it to you. And again, you're probably familiar with a lot of these subjects on here. The good news is most states allow us, if we have a policy in place that is as generous or more generous than what the state requires, allow us to use that policy. So we can go through, help you review your policies, compare it to the state requirements, and see if what we have already complies with that state's laws, and hopefully if it does, then we're good to go. Oftentimes, though, states have different accrual requirements or different amounts which require us to tweak our policies a little bit. And then the question arises, and this is something that we can work through with you as to whether you adjust the policies for everybody. So again, it's just easier to administer on the whole, or whether we have different policies for employees in different states. But we mentioned at the very beginning how some of these laws, it might not seem like the laws should apply to our employees who are working in the state because they're really reporting back to Michigan or they're using our computer services here in Michigan. Paid sick leave tend to be the type of laws that it doesn't matter where employees are reporting or to whom they're reporting. Most of these laws say if the employee is working in the state and if the employer is covered by the law, then the employee is entitled to paid sick leave. And so this is one of the things that, it's topic 4 here, but this is one of the first things we should look at when we're looking at our multi-state compliance, because this has affirmative requirements of us of what we need to be providing employees. We can't just react to the law when the employee says that he or she wants some break time. Employees need to be accruing their sick leave, and so this is something that should be at the foremost of our attention. Topic 5, paid disability benefits. This is something of a foreign concept to us here in Michigan because we don't have anything like it, but a few states require employers to provide not just disability leave, but paid disability leave. And most of these programs work in one of two ways. Either there's a state-funded or a state plan that's funded by deductions from an employee's pay. So essentially, you take a small amount out of each paycheck, you send it to the state service, the state ideally invests that and lets it grow, and then when employees need some sort of disability leave, they submit a form to you, they submit a form to the state, and the state gives them a certain percentage of their pay as disability leave until they're able to return to work. A lot of the states also offer employer-based plans or self-funded plans where the employers can operate it themselves. And of course, there are all kinds of different agencies and entities out there which help employers with these. But these, let's see, 1, 2, 3, 4, 5 states have some sort of paid disability benefit available to their employees. And the next one is paid family leave. This is similar to paid disability leave, especially in terms of how it's funded. We have a few more states here, and we lost Hawaii on the way. So I think the same states that offer paid disability benefits offer paid family leave as well, with the exception of Hawaii. We've got a couple different colors here in no legend, which I understand now is not very helpful to you, but let me explain it. So the red states, they already have paid family leave plans operational and running. And this is exactly what it sounds like. Employees are entitled to a certain percentage of their pay, paid from either a self-funded plan or the state plan, when they need family leave. Leave to care for themselves or others, leave for the birth of a child, just very similar to FMLA. The blue states, so we have Colorado. That's blue because Colorado will not start collecting premiums for its program until January of 2023. And Colorado employees will be eligible for benefits for the first time in January of 2024. Oregon is blue because that premium collection starts in January of 2022, with benefits starting in January of 2023. So typically states will start collecting benefits a year out and then issuing them to employees who submit claims after they've gotten a year under their belt. The Connecticut program and the Massachusetts program are both relatively new themselves as well. Connecticut started collecting premiums just at January 1st of this year, and Connecticut employees will be eligible for benefits starting next year. Massachusetts employees just became eligible for benefits on January 1 of this year. And finally, all the other leaves, or as we have titled it, I'm sorry, but you want to take leave for what? States have all kinds of different laws in effect that entitle employees to different types of leave. Some of them are, I don't want to say obvious, but they make sense. You see it and you think, oh yeah, employees probably should get leave for things like being a victim of a crime, or emergency responder leave, or maternity and paternity leave. But then there's things like voting leave. Some states require employers to give employees paid time to go vote in elections, or time to go participate in a political convention. Some states require employees to give Veterans Day off. Sometimes it's required, sometimes it's at the employee's election, but that's out there. My favorite is leave for where there are road closures in the county, either where the employer is located or the employee lives, because of a state of emergency declared by the governor. Yes, in the state of Pennsylvania, you can get excused leave if roads are closed because the governor has declared a state of emergency. So all kinds of other things. These are more of the, what I call kind of reactive. We need to be aware of them. We need to make sure employees are getting them, but they don't necessarily require us to take deductions from paychecks and submit them to the state, or to accrue paid leave for sick time or anything like that. But still important things that we need to know about. So Sarah, those are all the fun leave topics that we're going to discuss this morning. And I think this is another good place to stop and let me take a sip of coffee here, but to see, more importantly, if we have any questions that we should answer at this point.
Right. Thanks, Matt. Wow, that sort of makes your head spin. And I'm a chart person, so I'm envisioning HR folks with employees in different states needing a color-coded chart to keep track of who might get Civil Air Patrol leave and organ donation leave and crime victim leave, not to mention paid sick time, et cetera.
I'm going to be honest. I didn't even know that there were Civil Air Patrols for certain states, and maybe that's me just not being aware of things that are out there. But I've learned a lot as I've looked at all these different states' laws about what's out there and what employees are entitled to.
Yeah, I've sort of been amazed at the volume of states that require Civil Air Patrol leave. It's it's quite a few, and it almost makes me surprised that Michigan does not have that law on the books. But many, many states do. I've yet to have a question from a client about civil air patrol leave. So please do me a favor. If you ever have a question, call me and ask me the question. I won't even bill you for my time, but I would just love to talk about it once.
All right, so topic 8, marijuana and drug testing. Is our current policy going up in smoke? Maybe, hopefully not, but we're prepared to help you work through it here. So this Christmas-colored map gives you an idea, a very general idea of what the country is looking like in terms of the legality of marijuana right now. A majority of states allow individuals to use marijuana in some form. The red states allow marijuana only for medical purposes. The green states allow both recreational and medical marijuana. Now, what's required of both employers and employees, of course, is different based on the state. And on top of that, each state has different requirements for drug testing, whether applicants and employees can be drug tested, whether it's just employees, what needs to be in a drug testing policy, what rights employees have if they test positive, and what sort of confidentiality protections are available to employees through the drug testing process. Now, the good news is most states allow employers to discipline or discharge employees who failed a drug test because of marijuana, just like here in Michigan. But to take one example, Arizona, which isn't necessarily what I would consider to be a hotbed of employee protections, Arizona says that an employer cannot refuse to hire an applicant who tests positive for marijuana if that applicant has a medical marijuana card. And in fact, if you have an employee who tests positive in Arizona for marijuana, and that employee has a medical marijuana card, he or she can only be disciplined or discharged if the employee was high at work. Is that what it's still called these days, high, or under the influence of marijuana? I think you all know what I'm talking about. So our general drug testing policies will work in most places, but we need to make sure that we look at the state laws to see that if there are specific requirements for the policies, that we adjust them and adapt them to comply with the laws, and to make sure that we know exactly what we can and can't do in terms of testing and if an employee tests positive for marijuana. I think it's funny. We've kind of we've badmouthed California here all morning because there are just so many California requirements that we have to work with, but Arizona's drug testing policies, I think, are actually more strict for employers to comply with than California. I'm sure now that I've said that, it's going to change at some point, but just goes to show you that we can't carry our assumptions about states all the way across the board. We need to look at all these individual topics. Topic 9, no, we're not going to reimburse you for your cell phone plan. Wait, what? It's required by law? Well, yes, in some states. Employers sometimes, employers usually will voluntarily reimburse employees for their expenses, but California, DC, again, I know not a state, but a place where we still have to worry about the laws. Illinois, Iowa, Massachusetts, Montana, and New York require reimbursement of business expenses. Now, this is different based on the states. So Iowa, for example, just says if an employee submits a reimbursement according to your plan and it's been authorized, then reimbursement has to come within 30 days. Easy peasy. Hopefully we're doing that already. Our favorite state, though, California, has a much different requirement. California says that employers must reimburse employees for all necessary expenditures or losses incurred by the employee. There is actually a case that went to the California Court of Appeals about the employee's use of personal use of cell phone, and the California Court of Appeals said that employers need to reimburse employees for their work-related personal use of their personal cell phone, even if that work-related use doesn't add on extra cost to the employee. So even if the employee had a cell phone plan already, was using the phone, the work-related use didn't cost any more, if using the cell phone is part of the job or required as part of the job, then employers have to reimburse for it. Illinois recently, about 2 years ago, passed a law that is almost identical to California's with one main exception. Illinois gives employers a little more freedom to maneuver in terms of authorized expenditures, and also requiring employees to submit the expenditures or incur the expenditures according to the employer plan. So there's a little more flexibility there where it's not in close to absolute, you have to reimburse employees for everything. But Illinois and California are definitely two of the states where if we have employees out there and they're using their personal devices, or with remote working, if they are using their home internet to work, there may be a certain entitlement to the employees for reimbursement for those expenses. So we point this out just so that if you are getting requests from employees in those states for reimbursement of expenses, let's chat before you outright say, no, we're not going to reimburse you for that, because in some of these places, there is a legal entitlement to reimbursement. Finally, topic 10, and we've alluded to this, and here it is. Should we think twice about allowing employees to work in some states? Well, in 2019, U.S. News and World Report, showing that there is absolutely nothing that they won't rank, ranks the top 10 states for workers' rights. And I'm sure you could guess what number one was, because we have alluded to that throughout the presentation today. So they said it was California, Washington, Massachusetts, Maine, Oregon, Rhode Island, Vermont, Connecticut, Minnesota, and New York. I'm not sure, after reviewing a lot of these states' laws, that I would necessarily agree with the order, although I generally agree with the states that are part of that list. I might add Illinois as well. Illinois has seemingly gone out of their way in the past couple of years to try to be California. And so that's a state I'd probably add to the list. As you've noticed, though, Michigan is not on the list. Michigan did not even sniff the list, which I think goes to show you how fortunate we are to work here in Michigan, and the relative ease that we have been complying with its state laws and regulations. And of course, I mean that a little bit sarcastically, because there's nothing easy about working with Michigan laws and regulations, and they present a whole host of issues and problems for us, which we're able to work through and figure out. But again, I think it just goes to illustrate how many affirmative requirements are out there in some of these other states. And so, as we say here, the laws and regulatory schemes of these states can make compliance an administrative nightmare. And so topic 10B is, can we really tell people that they can't work in a certain state? And we already gave you the answer, but yes, work location is not a protected characteristic. So from a strictly legal perspective, yes, we can tell employees you can't work in California, or you can't work in New York. Illinois might be a little more difficult just because it is so close to us, but we could tell employees, yes, you can't work in Illinois. Now, of course, there's a but, and it's a big but. We need to be careful to not step into a retaliation claim. And so what I mean by that is, let's take that California employee. This is somebody who, for the purposes of this conversation, we'll assume is covered by California law. And a California employee reaches out to you and says, I'm not being properly paid my minimum wage in overtime. I'm working over 40 hours, over 8 hours in a day, and I'm not getting paid overtime for that. In that situation, our response can't be something like, that's it, you're fired, we're never hiring anyone in California again. And I hope that goes without saying, but we need to tread this line carefully to make sure that we are responding to any claims or any sort of notice that employees give us about a possible violation of the law, and that we not take a retaliatory action and prohibit the employee working in the state because of that protected activity. So after today's presentation, if you sit down and talk with your favorite Miller Johnson employment attorney or your employment counsel, and you decide, you know what, it's just not worth the risk of having employees work in California. We haven't heard anything from our California folks. It's just we don't want to be dealing with it. That's one thing. But if we're dealing with all kinds of different complaints and issues from our employees in that state, then we need to think twice before we necessarily pull the trigger that quickly, because we don't want to step into a retaliation claim. So now that we have unintentionally, or I guess it wasn't necessarily our goal here, but probably scared the living daylights out of you. Is it all hopeless? Sarah, is there a way that we can avoid this total doom? Please tell me that there's something good that we can take from
There's
this.
at least a path to compliance. Is that what you're saying, Matt? Right?
That's what I'm asking.
Eliminate all the gloom and doom. Yeah, before I get to that, let me just ask a couple of follow-up questions.
Sure.
Can you quickly just touch on posting requirements by state law? Are there some states that also have additional employee notice and posting requirements?
That's a good question. So yes, every state has its own employment posters and notices that need to be distributed to employees. And usually that's not a big issue. We post those in the lunchroom or the break room and we're all set. But when we have employees working remotely, there either might not be a lunchroom or a break room, or we're not there to post them. So we recommend that you distribute those to employees electronically. You can send them via email. You can post them on an intranet site.
Great.
As somebody, Sarah, you and I, we both litigate, and so I can see a claim. I've never had a litigation claim about posters, but I could see somebody complaining to the Department of Labor in a specific state that they didn't get a poster. And so my only recommendation would be is to make sure that you track when you distribute those notices and those posters, whether it's you save the email that you sent to the employee in the personnel file, or you have them sign an acknowledgement that they received them, they saw them, just something that we can show the Department of Labor when they come in and do their investigation that we complied with the notice posting requirements.
Okay.
But I don't think we need to set up a physical location just to post some posters.
And most of those posting requirements do allow for some sort of electronic form of posting, which is helpful for people working remotely, to your point. Let's not have to go to the house and post it in the kitchen. Okay. Wonderful. One other follow-up. So again, with this idea that maybe we just don't want to have employees working in some states, California, right? Poor California. We're just beating it to death this morning, but it kind of deserves it. And I understand your point, Matt, about potential retaliation, but is there opportunity here to be more proactive and simply say, we aren't going to interview or hire anybody who lives in a specific state, right? It's not retaliation if you ask to, because we're going to say at the front end, we're just not going to. And also, is it okay to tell current employees, look, if you want to make a request to work remotely, you can, but we are generally not going to approve requests to reside in this list of states. We can do those things, right?
Yep. Yeah. Again, the law may one day catch up with it, but as of right now, the location, residence of an employee, state of residence, location of work, none of those are protected characteristics. So yes, we have every right to say those things. Okay.
Excellent. All right. And I do just want to mention one more thing, just in case you guys are feeling comfortable with what we've said so far. One piece that we are not touching on in this presentation, but needs to also be on a list of compliance when you think about employees working in other states, is the state and local tax requirements, okay? We're focusing on employment laws in this presentation. However, different states and cities have different rules about what it means to have a business presence in that area, and whether a tax filing is required, and also whether you have to register as a company or a corporation in that area. And those vary. We do have folks here at Miller Johnson that know about that, but honestly, I'm seeing that clients' accounting firms are a good place to start to understand what those requirements are as well.
And one thing I'll add to that, Sarah, some states have passed either executive orders or maybe even laws that have COVID exceptions. So California is an example. Surprisingly, California has, I believe it's an executive order that makes an exception for employees who are working remotely in California, and they're only there specifically because of a COVID remote work order, and they're not going to be permanently working from California. And in that case, there are some exemptions from deducting income tax from the pay of that employee. So there are some local requirements out there which might make this an easier pill to swallow. But to the extent that employees are working remotely and it's not COVID related, or after COVID is, again, quote unquote, done and employees continue to work remotely, those issues will certainly be at the forefront. And like you said, something that takes a comprehensive team-based approach to make sure we have all our bases covered.
Yep. And to be clear, in California, that's only with regard to the tax piece. That's not regard to the employment law piece. Okay.
Correct.
So let's talk about then where we go from here. And I'm going to be honest, we've been working through this issue with many clients. And by issue, I mean employers that wake up from the last year, COVID, and otherwise, and the light bulb goes off in their heads and they realize they suddenly have people working all over the country. And also employers who are contemplating what is going to happen with their current workplaces. Are we going to bring everybody back? Are we going to have a more flexible remote work policy in which people really could live anywhere they want? So as businesses are facing these things, we've been doing a lot of work helping them think through options, and also on the compliance side of things, okay? So in terms, our suggestions in terms of current compliance, these are businesses that currently have employees, businesses that might be based primarily in Michigan, and now they have employees, 1, 2, 3, 4, 5 employees in 17 different states, okay? If that is you, my suggestion is that what you need is, first of all, a checklist of the requirements for each of those states. And by that, I mean something that you can put your hands on that quickly tells you all of these weird nuances that Matt's been talking about, right? So that you can flip to Arizona when you get somebody apply for a job who lives there. And you can eyeball it and you can say, okay, what are the requirements in that state, okay? And also, for example, you have an employee, let's say in Massachusetts, right? And you want to drug test the employee, and you need to know quickly whether there are special rules with regard to that. You need a checklist to look at to answer that question carefully. All of those things that you guys all know with regard to Michigan law, but you don't necessarily know with regard to other states. So you need a checklist like that for your own internal administration. And then you need some sort of handbook or policy addendum that has these different requirements for each state. I have tried hard to make handbooks, create handbooks that are compliant with many states, and have the handbooks in them have exceptions, right? If you work here, here's the rule. If you work in this state, here's the rule. And I will be honest, I think they are very difficult from an administrative standpoint, and they read terribly to employees, right? It sends the message that everybody's under different rules and you have certain advantages if you're willing to move to Colorado. And so I don't love that approach. What I do like is having one handbook. And if you're primarily based in Michigan, it would be fine to have the handbook fully compliant with Michigan law, and then have one page or short addendums for other states that you give to the employees working in that particular state when they get a handbook. So if I'm an employee who's working in Illinois, I get the handbook and I get the Illinois addendum that tells me, oh, by the way, you also get Civil Air Patrol leave, right? And whatever else. And you get to bring your gun to work and leave it in your car if you want, okay? So those are the two important pieces of compliance. We have, Matt and his team have developed those things for I think just about every state now, Matt, isn't that right?
We're just about covered. I know more about all the states out there than I ever cared to know.
So we have those resources available. So, and we are working to leverage that work for many businesses. In other words, we have done that work, we've done the research, and so reach out to either me or Matt if your organization is in a position to need those things, so we can talk about what it would look like and what the cost might be. So that's the easy part, right? That's the how do I get into compliance now? And then the second piece, of course, is how do I keep in compliance? And we've done a lot of brainstorming and thinking here at Miller Johnson as to how we accomplish that. And what we've come up with is a subscription service that we are going to provide, and we're going to launch it, I think, probably next week, in which we will notify anybody who signs up of developments, legal developments, changes in all of the states. So it's going to look like a bi-weekly update with changes in each state in alphabetical order. Hopefully some weeks there will be not many, but I would expect with 50 states there's going to be one or two things to make sure everybody knows about every state. So we at Miller Johnson will be tracking legal developments in all 50 states. The reason that we're going to be providing this through sort of what I'm calling a subscription is because I feel strongly that all of you businesses who need that information can leverage that need and let us provide it to you in a much more efficient way, right? In other words, we don't want any of you individually paying lawyers or anyone else for that information every week. Instead, we could provide it to all of you at once and be able to do so in a very cost-effective way for like an entire year. So that's our idea. And quite frankly, we are open to other concepts, ideas, requests, et cetera, if you think a different model would work better for your organization as well. I'm going to pause there, Matt, and while I look at, there's a couple more questions. While I look at what those are, do you have anything to add to what I just said?
The only thing I would say is that these are obviously complicated issues, and we're not trying to scare you or paint this doom and gloom scenario, but we're here to help in any way we can. We want to make this easy for you so that you can stay on top of things and remain compliant with the laws regardless of where your employees are located or working. And so, we have the team in place that has looked into the laws of each state. We've built these checklists, we've built the addenda, and we're here to help. And so in any way we can do that, please let us know, because like I said, these are complicated, it's heavy stuff, and it takes a team, and we're happy to be part of that team for you.
Exactly. So, again, if you are looking for more information about either the initial compliance piece, the checklist, or the addendums, please feel free to reach out to me and Matt, and we'll just be happy to talk to you about your needs and what's going to make the most sense. And then on that secondary compliance piece, keep an eye out in the next week or so, and we're going to launch that subscription service, and then you'll have a much better idea of what that will look like as well. So thank you for joining us this morning, and I appreciate we've gotten a lot of comments. Thank you. This is timely, et cetera. So glad to hear you guys found it valuable, and I hope you all enjoy the sunshine and have a great weekend. Thanks so much.
Have a good one.